It was $400 for the tether just to buy it, and it was $300 for a month just to get it.
The last thing I want to do is put you in jail because you're causing an upset to the court.
I agree. Personally, I agree with that. What up, man?
I need you to relax.
Otherwise, I'm cool.
You're here under review. Yeah,
I'm
here is
Mr.
Finley.
All right,
Mr. Finley, you have to stop.
review.
You have to stop. It's a review to get you back on the right track.
Right, but here's another thing, and here's another thing, and when we need people to, you gave me time, that would be like giving someone time for a parking violation. It don't make sense, Andrew, you smart, man.
That's not how this works. I'm gonna give you
How
a
that-
chance to relax.
Right. Just stand here and let's do the review.
Mr. Young?
I'm still recording. And you can read it, all the statutes you want. If it doesn't make sense, it doesn't make sense, Andrew.
Mr. Finley, I have to hold you in direct contempt for
Oh.
continuing to interrupt.
Let's go
the
with
court. You're sentenced to a day.
Good morning, Your Honor. Elizabeth Smith, P63010, appearing on behalf of Midland.
Okay, and then I see the defendant and counter plaintiff. Please state your name for the record.
Rachel Langoni.
Your volume is a little low.
Okay. Is that any better?
That's better. Okay, so today was the date that was scheduled for a motion for summary disposition that was filed by Midland. Let's see. And let's see. They're asking for the court to strike, excuse me, the defendant's answer and dismiss the counterclaim. Saying that the counterclaim doesn't seek relief that the court could grant. I'll let you make your motion on the record, Ms. Smith.
Thank you, Your Honor. To address the counterclaim first, I'm sure the court has had opportunity to review the counterclaim. It's a two-line counterclaim saying that she is seeking dismissal of the claims against her and asking for an award of $3,744. It does not go into any detail about anything my client would have done wrong. So there's really no basis on which to grant any sort of relief as to the counterclaim. As for our motion for summary disposition, reviewing the defendant's pleadings filed, the crux of the matter is she doesn't believe that she owes anything to Midland because the original creditor was a different entity. So it was a Children's Place credit card held through Comenity Bank. The account was used. We attached about a year and a half worth of billing statements to our motion showing use, purchases and payments on the subject account. In December of 2021, the account was charged off and sold to Midland. Also, as part of our documents is a letter sent by Comenity to Ms. Langoni explaining that the account with Comenity has been charged off. It was purchased by Midland Credit Management. Any further communications and or payments were to be made with Midland Credit Management. Ms. Langoni did in fact contact Midland and set up a payment plan. The payment plan was ultimately defaulted with only 1 or 2 payments having been applied to the account. So there's just really no issue left to resolve. Midland owns the account. The balance due and owing, there's no dispute as to that. There's no dispute that Ms. Langoni had the original card. The only issue is her belief that she doesn't have to pay Midland. And again, based on the proofs provided by Midland, and the fact that there was in fact a payment plan set up with Midland,
Welcome back to the channel. Today's episode is one of those rare courtroom moments where reality outperforms comedy. We're diving into *2 chaotic legal showdowns. First, A defendant who basically personal bests a contempt charge by speedrunning his way into jail in under 2 minutes. Yes, you heard that right, less time than it takes to microwave leftover pizza. And then, just when you think the courtroom chaos can't escalate, we move into our second case, where a borderline sovereign citizen starts dipping her toes into pseudo-legal fantasy land while trying to dodge a simple credit card debt. What makes today's cases especially wild is how both defendants essentially sabotage themselves, one through impatience and disrespect, the other through confusion, misplaced confidence, and a sprinkle of misinformation. But the real star of these clips isn't the chaos, it's how the judges handle it. You'll see a mix of patience, restraint, and finally, that okay, I've had enough moment that every judge hopes they never have to reach.
I did try to contact legal aid and get some advice. The only thing that she told me that I could do was to ask you to amend my response. As far as what she sent, I still, when we were here the last time and I met with counsel in a separate room, I still maintain that I would like to see the contract. Whether that's, I mean, especially between myself and Comenity, to see that they were legally able to sell the debt. Because if I could go to trial, I would show that the chances that the Comenity was paid for the debt. And I want to be able to show that. It's very different because if I were to go to court with Comenity, that would have to go through a federal court. It's very different than saying that
let me get some clarity here. You're not disputing that you had a Children's Place account, correct?
Correct.
You're disputing, and you're not disputing that there was a balance of $643.63?
No, I'm not disputing that.
Okay, your dispute is that you have paid that $643.63?
It was paid when I opened the account.
It was paid by who?
Right here, you can already feel the tension simmering. The judge is practically begging this defendant to recognize the gravity of what's happening. She's outlining the real financial burden of monitoring equipment, $400 upfront, $300 a month, something defendants often underestimate until it hits their wallet. But while the judge is trying to create understanding and keep him out of jail, he just keeps interrupting, pushing buttons he really shouldn't be pushing in a courtroom. This is where the audience should take note. Judges hate being interrupted, especially when they're actively trying to help. The defendant misreads the situation, thinking he's negotiating when, in reality, he's inching dangerously close to contempt. You can almost feel the moment the judge's patience starts to drain, and we're only seconds away from
It's going around online. It basically comes down to an argument that credit cards aren't real money, and somehow by opening a credit card, Comenity is really doing some other sort of banking thing, and it's not really money that has to be paid back. You have to let her give her response because she's not actually drafted a motion or a responsive motion to you. And then I'll let you respond to what she's saying, but she's got to have an opportunity to make her statements as to what she believes her defense is. Sure.
So you're saying you didn't pay, you charged $643.63 on the Children's Place card, but you didn't pay for it?
I did pay on it at the time because I didn't realize what had happened. And when this all started, when I started questioning what was going on, I had called Comenity.
What do you mean what was going on? I don't know what that means.
When I was trying to understand the legalities of a contract and how the banking system works, I was just studying this on my own. And so I had called Comenity a couple times, spoke to 2 different people, and all I did was I wanted the original contract so that I could learn the legal terms, how it works, the process. And when they kept telling me that they didn't have this contract, that's when I started asking more questions and learning that how important contract law is, and the fact that it's somehow magically disappeared. I don't understand why the most important legally binding contract would have just magically disappeared. So I started asking a lot of questions, and what I'm basing it off of is off of federal regulations, federal codes, the UCC 3. It's not what,
And here it is, the exact moment every experienced viewer recognizes as the breaking point. Notice how the judge transitions from conversational to corrective. At first, she's calm, even empathetic, but after multiple interruptions, she's forced to clamp down. When she says, "I'm going to give you a chance to relax," that's judicial code 4*, you're seconds away from a consequence you really don't want, but the defendant doesn't seem to pick up on the warning signs. He's stuck on comparing his situation to a parking ticket, and argument so off base it shows he doesn't grasp the seriousness. And anytime a judge tells you to stand here, that's not guidance, that's a last chance. Spoiler, he doesn't take it.
Valid defense, that you have not presented an issue of genuine dispute, you need to now plead to me something that makes me believe that there is an issue of genuine fact that needs to be resolved by either a jury or a trier of fact. And you've not yet provided me that. That's why it was important for you to respond in writing to their motion. I'm giving you an opportunity now to respond verbally, but I need to hear some information that would allow me to understand your mindset and why you believe that you can open a credit card and then charge a balance and then not have to pay the balance.
right, and that's.
So answer that.
It is very difficult to explain, but I 100% would not have disputed this with Midland. If that was the case, that I just wanted to borrow money and not pay it back. That's honestly,
Okay, so
that's not what it's about.
I don't mean to cut you off, but I'm trying to follow. So your dispute is that the past due debt was charged off. I'm not following what the dispute is.
My main, I feel like I need to, I obviously I didn't go to law school, so understanding this process is not easy for me. And if I lose the case, it's going to be because of a
And that's it, world record unlocked. Just like that, Andrew talks himself straight into a contempt charge and a 1-day jail sentence. It takes the judge only a breath to make her decision because he practically forced her hand. In court, direct contempt is applied when the misbehavior happens in front of the judge, and interrupting repeatedly, ignoring warnings, and challenging authority is the fastest way to trigger it. This moment is fascinating because the judge clearly didn't want to jail him, she said so repeatedly. But once a defendant shows he can't control himself long enough to complete a review, the judge must act to maintain order. It's swift, clean, and a perfect demonstration of how courtroom behavior can make or break your outcome.
That you used that credit card to purchase some things, and then you didn't pay the credit card. And I'm trying to understand, but you said that the credit card, it was paid, and I'm trying to figure out how was it paid if you didn't pay it?
It's the banking process when I provide my social security number and did not fully understand what I was signing and what I was signing over.
Okay, so because you signed a contract for a credit card and you didn't fully understand, you think that that's a defense?
Well, see, that's the tricky thing is my defense would be different with Comenity versus Midland. So anytime
we're not talking about that. We're not talking about what hypothetically your defense would be with Comenity. This is Midland Credit Management versus Rachel Lamco.
So I'm maintaining that they don't have there's no contract to base any of the allegations in the papers that Midland has submitted. It's all based off of if there was a contract, and there is no contract.
There's no contract, you mean, between you and Midland Credit Union? Is that what you're saying?
Or
credit management?
Or myself in Comenity. Nobody has that contract.
No, I didn't ask you if anyone had the contract or anyone's produced it. I've already stated on the record that you signed a agreement with Comenity.
Right, but usually there's clauses in that agreement if they can legally sell my debt to a third party. So I would like to see that they could legally sell my debt to the third party.
Okay, so your defense was that you wanted to see evidence that they could legally sell the debt to Midland?
Yes.
Okay. Any other defenses?
No. Thank you.
Okay, and then you filed a counter suit.
Yeah, that was for my time doing
For
it.
your time?
Yeah,
What do you mean for your time?
for responding and getting this suit that I don't agree with, and I figured if the attorney would get paid for.
Now we shift gears into a totally different flavor of courtroom chaos, the sovereign citizen in training. This defendant hasn't gone full softsit yet, but you can already see the early symptoms: questioning debt ownership, demanding contracts she isn't entitled to, and introducing arguments that sound legally profound but collapse under even light scrutiny. This case is a civil debt matter, simple, straightforward, heavily documented. Midland Credit Management purchased a charged-off account and is now trying to collect. But our defendant is gearing up to argue technicalities she doesn't fully understand. The contrast between her confidence and her legal footing is about to create peak court.
Which I'm going to cut to the chase. It's very clear to me that you have opened up a credit card and you failed to pay the debt. Now, whether or not committee had the right to sell or transfer your debt to another entity, which is common in when you open up a credit card, that's unknown. Did you provide that information for her, Ms. Smith? We can't hear you. You might be muted.
Sorry, I did mute myself because I had to cough. I don't believe so, other than the letter sent by Comenity to her indicating that the account had been sold and Midland now owns it and was able to exercise full rights to collect on it. That was sent to her back in December, excuse me, of 2021. And that was included as part of the documents attached to our motion. And then again,
Okay.
I would also emphasize that there was a payment plan made with Midland as well, so.
She made a payment plan with Midland?
Yes, there were two $15 payments made, to the account.
When?
This was, give me a moment, Your Honor, it's in the motion. They were made, there was one payment for $15 made August 28th of 2022. That payment was actually returned on August 31st.
It is a clean, textbook argument from the plaintiff's attorney. They laid out the facts: the card was used, the statements exist, payments were made, the account was charged off, and Midland bought the debt *, all fully documented star. They even included the letter informing the defendant that the debt had been transferred, plus evidence she began a payment plan with Midland. His is what lawyers dream of, a case with zero factual disputes. When the defendant admits she had the card, admits she owes the balance, and the only remaining issue is a belief that the debt sale isn't valid, the attorney can walk the judge through the logic